Hello, my name is Bob Ash. I'm with the law firm of Riezman Berger in Clayton, Missouri. We're doing a little video for you today that gives you a summary of the 2013 gift and estate tax rules. My goal will be to give you an introduction to the transfer tax system, tell you what the exemptions are for 2013 and how this could be relevant to you in your own estate planning. Please keep in mind that this is general advice, and any personal legal advice you should seek from your own independent legal counsel. So without further ado, the 2013 gift and estate tax rules. By way of background, we do have a transfer tax system. The taxes are often called the gift tax and the estate tax. There's a supplemental generation skipping transfer tax also that can apply to certain kinds of transfers, and all of these taxes are designed to tax the transfer of assets either during one's lifetime or at one's eventual death. The gift tax, for example, would be imposed on the donor of assets that were transferred to a recipient of those assets. The estate tax is a tax that would apply at one's death upon the transfer of the assets of a deceased person down to that deceased person's beneficiaries or heirs. So the taxes are federal taxes that do apply upon a transfer during life or at death. Each individual, with some exceptions with respect to non-residents or to aliens, have exemptions against the federal estate tax or the federal gift tax. So it's important to know what these exemptions are, which is the main purpose for the present video. So in January of 2013, the President signed a new tax law into effect. On January 2nd of 2013, we got new exemptions that are actually designed to be permanent exemptions. Permanent meaning there aren't any more graduations to the exemption scheduled to take place in future years, in contradistinction to the scheme that has been in effect for the last decade or so, where the exemptions have been moving over the course of time. So we have 2013 exemptions. These exemptions are permanent amounts, albeit they are indexed for inflation. So they will go up in increments over the next few years. But the federal gift tax exemption this year is $5,250,000. That means an individual can transfer up to $5,250,000 with the use of their lifetime exemption to one or more donees and not be subject to the gift tax. If the amount of gifts were in excess of that exemption, those transfers would be taxable, and the gift tax likely would apply. Similarly, when a person dies and leaves assets over $5,250,000, those assets would generally be subject to estate tax. An exception would be if the transfer was to a surviving spouse in a manner which qualified for the estate tax marital deduction, it's called. And in estate planning, we try to structure your estate plan so that your assets can transfer to a surviving spouse and they make use of that deduction. In addition to the gift tax and the federal estate tax, there's a federal generation skipping transfer tax, which is a tax from a person to someone who's deemed to be 2 generations or lower below the person making the transfer. It's called the GST tax often. And that tax exemption available to each individual is also $5,250,000. So we have a gift tax exemption, an estate tax exemption, and a generation skipping transfer tax exemption. Each of these exemptions is $5,250,000. In the case of the gift and the estate tax, it's a combined exemption, often called a unified credit, meaning you can use the exemption during your lifetime. The exemption not used during your lifetime is available at your death. If you used all the exemption during your lifetime, it would not be there to be used at the time of your death. So it's a unified exemption with respect to the gift and estate tax. That would be the summary of the current tax laws. Again, these exemptions are scheduled to remain in place permanently, only indexed for inflation, meaning they could go up in increments over the course of time. The goal of your estate plan should be to use these exemptions as much as possible to defer or avoid estate tax at your eventual death, or if you wanted to make transfers during your lifetime. I wanted to make a quick reference to one other new rule that was implemented in 2013. It's called portability. Portability means for a married husband and wife, a married spouse, and his or her spouse, that at the death of one spouse, the surviving spouse can use the unused exemption of the predeceasing spouse if an election is made to that extent. So to reiterate that, when you have a married couple, the first spouse dies, if the first spouse's assets aren't up to the amount of their exemption, then the surviving spouse would be able to use the rest of the first spouse's exemption as well as all of the surviving spouse's exemption, again, if there was an appropriate tax election made after the predeceasing spouse's death. So that concept is called portability. There are important advantages to that, and there are also some important drawbacks or some limitations to portability. So all of these principles that I've given you today are general rules, and we would be glad to discuss with you in further detail how these might impact your estate plan. For some clients who've had long-term estate plans with the traditional AD, trust and estate plan, the current exemptions may lead you to revise your estate plan, perhaps even simplify it. In some cases, though, there may not be a need for any change whatsoever, and your current estate plan could be suitable on an ongoing basis. But in any event, these changes are very significant. You definitely should be aware that the changes have been implemented, and you should be aware of the impact that they would have on your own estate plan. So that is the summary of the tax law changes for 2013. Please contact us if we can give you any further information. Thank you.